Good morning, gentlemen. Fair law practitioners run by Lieutenant Colonel Atul Tyagi, advocate, and Anant Tyagi, advocate, brings out deliberately an important issue before all of you. This is related to contempt of court proceedings which were initiated against illustrious lawyer Mr. Prashant Bhushan by the Supreme Court. Uh, there are misgivings on the issue which appear due to long debates and deliberations which have gone into on the TV debates, which are generally orchestrated due to the alignment of the TV channels with the parties, with the people. So, we professionals think it is better we analyze it systematically within the purview of legalities and bring out before the general public. Well, what is exactly contempt of court? Gentlemen, when the constitution was adopted, contempt of court was made one of the restrictions on the freedom of speech and expression. Article 129 of the constitution confers power on Supreme Court, and Article 215 confers power on the high courts of the state to initiate actions against those people, those institutions who cause contempt. Now, what is contempt exactly? There are three forms of contempt. One, words written or spoken, signs and actions that scandalizes or tend to scandalize, or lower or tends to lower the authority of any court. Second, prejudices or interferes with any judicial proceedings and interferes with or obstructs the administration of justice. वेल कोई नहीं कहता कि आप फेयर और एक्यूरेट रिपोर्टिंग ना करें. फेयर एंड एक्यूरेट रिपोर्टिंग जाहिर सी बात है कि इवन की कमेंट्रीज में भी जो लॉ की कमेंट्रीज होती हैं उसमें की जाती है. दैट इज नॉट कॉन्टेम्प्ट ऑफ कोर्ट. बट while the matter is on, while the judgment is yet to be unrolled, derogatory words or prejudicial words or words to that effect can cause, can amount to, can be taken as the contempt of court. Hence, one has to be very careful that the words spoken or words written do not amount to vilification and dishonor of the institution of the court. Gentlemen, there can be no doubt about the principle that any member of the public has a right to criticize in good faith, in private or public, the public act done in the seat of justice. However, the members of the public are required to abstain from imputing improper motives to those taking part in the administration of justice. Here, what happened exactly that the court provided number of chances to Mr. Prashant Bhushan to express remorse. Mr. Prashant Bhushan's background is quite dubious. If I recall his role in last 3 4 years, it's not it's not to be appreciated. He has supported militants connected to Jammu Kashmir affairs. He has demanded exoneration of capital punishment in case of Tiger Memon and the one who was involved in the attack on Parliament. He has supported Maoists. He is the first one to have contacted Mr. Kanhaiya when the JNU incident was on. In fact, JNU was on fire. That's the time when Mr. Prashant Bhushan chose to be in the center of the controversy. He is the one uh, in the first gallery of lawyers where the clients had gone to his office and beaten him hollow. After all, this condemnable incident, if had happened with only Prashant Bhushan and no one else, really makes us to uh, ponder over about his ways of working. He is one controversial person who makes statements to attract attention. He made the statement that all the CJIs, 7 to 8 CJIs, Chief Justice of India, were corrupt. Now, the basic rule of law is that everybody has freedom of speech and expression and also right to privacy and right to defend himself. Can we say that just based upon Mr. Prashant Bhushan's statement, we all should assume that 8 CGIs were corrupt? Were they not having their right to defend themselves? When they were not made parties in any suit and somebody just made a statement and ran away? In that case, the Supreme Court had taken this onerous and pious responsibility to come forward and initiate a Moto case. And it was so necessary also to protect the ijat of the apex court. It is not the question of saving one person or defending one particular CGI. It is the question of safeguarding the overall sanctity, decorum of the institution of the court. In one particular case, when Miss Arundhati Roy had also done contempt, that time the bench made a statement. Our shoulders are broad enough to shrug off comments. Well, that was that statement, but this time this the bench was not in the lighter mood. They had really understood the overall hidden agenda of Mr. Prashant Bhushan to denigrate the courts, institutions, the government for his personal ulterior motives. So finally, this contender bought it. He was ordered to deposit rupees 1 or to be ready to face jail for 3 months and also uh, refrain from practicing law for 3 years. By depositing rupees 1 on the same day, Mr. Prashant Bhushan, in a manner, accepted his guilt. And that is a catch 22 situation what Supreme Court created for him. With that, it appears that this trend of making irresponsible statements by the lawyer community in particular shall come to a naught. Thank you.